This podcast uses AI-generated content. All information is for general purposes only and does not constitute financial, investment, legal, or regulatory advice. Listeners should verify information independently and consult qualified professionals for personalized guidance. Welcome to the Luxembourg Fundcast. On this 16th of July, 2025, we're taking a deep dive into something really quite monumental for Luxembourg. The Law of 7, August 2023, on the preservation of businesses and modernization of bankruptcy law. This isn't just another piece of legislation, folks. It's arguably the most significant overhaul of the Grand Duchy's corporate insolvency framework in over a century, and it clicked into gear back on the 1st of November 2023. Imagine a legal system, sort of rooted way back in the 19th century, groaning under the weight of modern business, often forcing businesses that might have survived into outright liquidation. That's the challenge Luxembourg faced, really, until this pivotal law stepped in. It represents a profound paradigm shift, doesn't it? Moving us away from that rigid, liquidation-focused past towards a modern EU-aligned rescue culture. It's all about giving viable enterprises a second chance.
Exactly. Its purpose is elegantly twofold, you could say. On one hand, it's about meeting a legal obligation directly transposing the European Union's Directive 2019/23 on preventive restructuring frameworks. And this isn't just ticking a box, as you said. It's about aligning Luxembourg with a harmonized European standard, which helps capital move more freely, promotes that second chance idea for entrepreneurs, and crucially prevents the unnecessary liquidation of businesses that could actually recover. And on the other hand, it's really about clearing out the cobwebs. It repeals and replaces a whole host of outdated domestic procedures that, frankly, had fallen into disuse. So now we have a coherent, modern toolkit for businesses facing financial distress.
So for professionals like you listening, navigating the complexities of the European market, understanding this new landscape isn't just academic homework, is it? It's really a strategic imperative. Before we unpack all the intricate details, let's maybe highlight 3 critical takeaways you'll gain from our conversation today. Think of these as your instant aha moments. First, we're seeing a completely new philosophy of rescue, embedded in Luxembourg law now. This legislation introduces a comprehensive toolkit, everything from confidential, out-of-court amicable agreements to powerful court-supervised judicial reorganizations. The main goal: preserving viable businesses. It's a complete flip from the old liquidation-first mindset, a total turnaround. Second, and this is truly paramount for our financial community listeners, the supremacy of the Luxembourg financial collateral law is preserved, actively affirmed even. Those robust, creditor-friendly protections you find in the Law of 5, August 2005, on financial collateral arrangements, they're explicitly carved out from the automatic state of proceedings.
Which is huge.
Absolutely. It means those crucial security interests remain rock solid. And third, this law isn't just theory anymore. Since its implementation over 18 months ago, we're seeing emerging case law providing crucial clarity. The Luxembourg courts have been busy interpreting key provisions, giving vital guidance on concepts like business in peril and the powers of court-appointed judicial representatives. So this judicial activity is rapidly moving the framework from, legal text to established practice, providing real-world predictability for the market.
Absolutely. And with those key pillars in mind, let's now proceed to a more granular examination of the law itself. Let's make sure you grasp the who, what, when, where, why, and how of this truly transformative legislation.
Okay, so to fully appreciate the magnitude of this reform, we really need to understand its context first. It sounds like it was a mix of external European pressure and, well, pressing domestic need.
That sums it up well. The immediate driver was certainly that legal obligation to transpose the EU Directive 2019/23 on preventive restructuring frameworks. And this landmark directive isn't just some bureaucratic exercise. It's a strategic move by the EU to harmonize restructuring law across member states, which in turn directly facilitates capital movement and promotes that vital second chance for entrepreneurs. It's really about preventing the unnecessary liquidation of businesses that could otherwise be saved.
But beyond that EU mandate, the need for reform was deeply rooted right here in Luxembourg's own legal reality, wasn't it? The pre-existing framework dating back to the 19th century. I mean, think about that. Formal restructuring procedures like gestion contrôlée, concours préventif de la faillite, and société de paiement. You mentioned they were so rigid, so cumbersome, they were hardly ever used. It sounds like they were almost relics.
They absolutely were. Relics is a good word. This created a rather perilous legal vacuum where, paradoxically, formal bankruptcy and liquidation often became the only practical path for companies in distress. The 2023 law decisively addresses this by completely repealing these obsolete mechanisms. It fixes a strange situation, really. Luxembourg, celebrated globally for its modern corporate and financial law, had this stark contrast with its archaic insolvency law.
Right.
The EU directive basically acted as the necessary catalyst to bridge that gap, strategically harmonizing the country's entire business law ecosystem. It felt like a missing piece, and now it's finally slotted into place.
Okay, so this new law defines its scope very precisely, applying to most commercial actors, but carefully carving out the highly regulated financial sector. So who's in and who's out exactly?
Well, the provisions apply to a broad range of entities you'd typically encounter. So traders, commerçants, who are natural persons, commercial companies like the Société Anonyme, that's the SA, and the Société à Responsabilité Limitée, or SARL. And importantly, it also includes the Special Limited Partnership, or Société en Commandite Spéciale, often called the SCSP, which, as you know, is a huge vehicle in the alternative investment fund world. Civil companies, Société Civile, and even craftsmen, artisans, also fall under its scope. So quite wide-ranging.
And perhaps even more critical for many listening who's explicitly excluded.
That's a crucial point, definitely. The legislation carves out a specific list of regulated financial entities. These are ones already subject to their own special insolvency and resolution regimes, often under the direct eye of the CSSF, the Commission de Surveillance du Secteur Financier. So this includes credit institutions, investment firms, insurance and reinsurance undertakings. Also, undertakings for collective investment UCIs, like UCITES, specialized investment funds, SIFs, reserved alternative investment funds, RAIs, investment companies and risk capital, SICARs, and finally, securitization undertakings that issue financial instruments to the public on a continuous basis.
So quite a specific list.
A very specific list. And this careful exclusion reflects a deliberate policy choice to sort of ring-fence the core regulated fund industry. These entities already have detailed legal frameworks for winding up and liquidation, rules designed specifically to protect investors and maintain market stability.
Makes sense.
So the new law applies more to the operational and holding layers, things like holding companies, SOPARFIS, and general partners, but crucially leaves the regulated fund products themselves under their own distinct regimes. This maintains certainty, predictability for fund managers and investors, avoids disrupting a sector that already has its own well-established rules.
Right, so the new law introduces this really multifaceted toolkit. It's designed to address corporate distress at various stages, offering a whole spectrum of options. It's not a one-size-fits-all thing. And in a significant departure from the past, the law sets up a framework for proactively detecting companies in financial difficulty. It seems like it transforms the state's role from just watching to being, well, a proactive watchtower. That's a big change, isn't it?
It absolutely is. A huge shift. Responsibility now lies with the Minister for the Economy and the Minister for Small and Medium-Sized Businesses. They access official data sources, acting as what the law calls flashing indicators or clignotants of potential distress.
Clignotants, like warning lights.
Exactly, like warning lights on a dashboard. And these aren't just random flags, they include specific triggers. Things like failing to pay Social Security or VAT debts within 3 months of the due date, or default judgments against a debtor who isn't contesting the claim, notifications of redundancies for economic reasons, and even information from annual accounts filed with the Central Balance Sheet Office that's managed by STATEC, the National Institute of Statistics and Economic Studies.
So when this data suggests a company's continuity is at risk, the competent minister actually invites management in for a chat to gather info and tell them about the reorganization tools.
Yes, exactly. It's almost like a supportive intervention rather than just waiting for things to collapse.
More proactive.
Much more proactive. And further institutionalizing this, the law creates a new public body, the Unit for the Evaluation of Distressed Enterprises, or Cellule d'évaluation des entreprises en difficulté. This unit, made up of civil servants from key public administrations, has a primary job: assessing the appropriateness of bankruptcy petitions, especially those started by public creditors. And what's interesting is that the operating costs of this unit are fully borne by the state.
That's significant. So this system really recalibrates the relationship between the state and the private sector, allowing for much earlier identification and engagement with struggling companies. Feels like a genuine effort to prevent things escalating. Now, for businesses seeking discretion, the law provides this flexible, largely out-of-court procedure, Reorganization by amicable agreement. Reorganization par accord amiable. This sounds like a real game changer for those who want to keep things quiet.
It truly is. This mechanism lets a debtor negotiate a restructuring agreement with all, or at least two, of its creditors. The aim is reorganizing assets or activities. The key here is confidentiality and freedom from cumbersome formalities. That's a major draw for companies wanting to resolve issues discreetly.
So the main step is the debtor petitions the district court for approval, the homologation, once they've reached an agreement. Is the court just rubber stamping it?
Not quite a rubber stamp, but its role is limited and specific. The court mainly verifies that the agreement's purpose is genuine reorganization, not some disguised liquidation or a way to defraud other creditors. And crucially, the decision isn't published. That's vital for maintaining confidentiality.
Right.
And despite its apparent simplicity, this homologated amicable agreement carries real legal weight. It becomes legally enforceable, executor. It's shielded from clawback in a future bankruptcy, even if it was concluded during that sensitive hardening period, the period suspect.
Even if creditors knew about the problems.
Even if they knew, the law explicitly protects it. And participating creditors are also shielded from liability claims if the agreement eventually fails. That significantly de-risks it for everyone involved.
Okay, now for situations needing full court protection and authority, the law sets up a formal, public, and quite powerful procedure. Judicial reorganization. Reorganization judiciaire. This sounds like the more heavy-duty option.
It is. A debtor can petition for this when business continuity is in peril or on peril. What's interesting is this applies whether the threat is immediate or more long-term. And crucially, being technically bankrupt doesn't automatically block this procedure. That's a massive change from before. Companies aren't forced into liquidation just because of their balance sheet at a specific moment.
Right. So upon filing, the debtor has to specify one of three objectives.
Yes, they need to be clear. Either get a stay of proceedings to reach an amicable agreement, or get collective creditor agreement on a reorganization plan, or allow the transfer of all or part of the business by court order.
And the process starts with filing a petition with supporting documents.
Exactly. Documents showing the threat, financial info, and the case law emerging since late 2023 has been really helpful here. Courts seem to agree that a big gap between liquidity and liabilities generally meets the in peril test. But just having more liabilities than assets without an acute cash crunch might not block it if there's a real risk to continuity. Courts have shown some procedural flexibility too, which is good.
And this brings us to the automatic stay, the CSSF. This sounds like a critical lifeline.
It absolutely is. The moment a petition is filed, the debtor is immediately shielded from bankruptcy or judicial dissolution. That's powerful. Once the court formally opens the procedure, it grants an initial stay for up to 4 months. This can be extended, but the total maximum is 12 months from the initial judgment.
And during this stay, what happens?
Well, most individual enforcement actions by creditors are frozen. Contractual penalty clauses become ineffective. And importantly, the debtor can unilaterally suspend burdensome ongoing contracts. Any damages from that just become claims in the reorganization plan.
Okay, and now the big one for financing. The financial collateral law exception.
Ah, yes, the cornerstone. The law is crystal clear. The stay of proceedings does not affect the enforceability of security interests under the Law of 5, August 2005, on financial collateral arrangements.
So pledges over shares, bank accounts, claims.
Still fully enforceable, robustly so. This creates a fascinating dynamic, doesn't it?
It does.
The debtor gets breathing space from the general stay, but key financial creditors retain their leverage because their specific collateral isn't frozen. Their consent or forbearance becomes absolutely critical for any successful reorganization. It's a real balancing act.
Okay, so if the goal is a collective agreement, the debtor prepares a formal reorganization plan. How structured is that?
Highly structured. 2 distinct parts. First, a descriptive part. Company details, situation, causes of difficulties, creditor categories, and a reasoned statement on viability, why they think it can work. Second, the prescriptive part. Outlining the specific measures to satisfy creditors. Things like extending payment terms, reducing debt, maybe debt for equity swaps. And the plan's implementation can't go beyond 5 years.
And how does the voting work?
Creditors with claims from before the procedure, the créances sociétaires, are divided into classes. You have extraordinary stayed creditors, those with mortgages or special privileges, and ordinary stayed creditors, the unsecured ones. To adopt the plan, you need a double majority within each class. That means a majority in number of the voting creditors, and those creditors must represent at least 50% of the total debt value in that class.
A double hurdle in each class.
Exactly. Ensures broad support within each group.
And then there's this powerful new tool aligned with the EU directive, the cross-class cram down. This sounds like it could really shake up negotiations. How does it work?
Oh, it absolutely does. If a plan gets approved by a majority in at least one class but gets rejected by another, the debtor can actually ask the court to confirm it anyway.
Right.
Yes, but under strict conditions. Notably, the plan must have been approved by an in-the-money class, meaning a class likely to get something in liquidation, and it must satisfy the best interest of creditors test. That test means no dissenting creditor is worse off under the plan than they would be in a liquidation. It stops a single holdout class from wrecking a viable plan supported by others. It's a major strategic lever now.
And the alternative objective, transferring the business.
Right. The court can order the transfer of all or part of the debtor's business or assets to a third party to ensure continuity. Recent case law from the Court of Appeal confirmed this can even include foreign assets. But interestingly, they also clarified that just holding shares in subsidiaries doesn't count as a transferable activity.
Why not?
Because the law aims to preserve active enterprises, operational businesses, not just passive investment holdings. That distinction is key.
Okay, we've laid out the legal architecture. Now let's turn to the practical side. Successfully navigating this new regime really requires understanding the key players, the negotiation dynamics, and those crucial procedural steps.
Indeed. The law introduces or formalizes the roles of several key professionals. Each has a distinct role.
Right. First up, the company conciliator, the conciliateur d'entreprise. What's their specific job?
This professional is appointed by the relevant minister economy or small-medium businesses, but, and this is important, only if the debtor explicitly requests it. They have to be chosen from an official list, ensuring some quality control. Their role is purely facilitative, helping the debtor with reorganization efforts or brokering those amicable agreements we talked about. They're like a helper, a guide.
Okay, and then we have the judicial representative, mandataire de justice, and the provisional administrator provisoire. These sound more formal, court-involved.
They are. These are court-appointed roles operating strictly within a judicial reorganization. A mandataire de justice assists the debtor, who usually remains in possession, with specific, defined tasks assigned by the court. The administrateur provisoire, however, is a much more drastic step. They actually replace the existing management.
Replace them entirely.
Yes, but only in exceptional circumstances. Specifically, there needs to be evidence of serious and aggravated misconduct, manquements graves et caractérisés, that's threatening the business's continuity. A key court decision from January 2025 provided important guidance here. It confirmed this intervention should involve targeted, reasoned actions, not just taking over day-to-day management. Proportionality is key. And that ruling also confirmed that any interested party, even a creditor, can ask the court for this kind of intervention. So it's a powerful tool, but clearly meant for serious governance failures. Hashtag the art of legal negotiation in a restructuring context.
So this new law fundamentally reshapes how negotiations happen between a distressed company and its creditors. Sounds like both sides have new cards to play.
Definitely. For the debtor, the main leverage is clearly the automatic stay, the sursis. It forces that pause, halts most creditor actions, and creates vital breathing room. And the ability to unilaterally suspend burdensome contracts that further strengthens the debtor's hand, letting them shed liabilities that could sink the whole effort.
But creditors have powerful tools too, right?
Absolutely. That best interest of creditors test is a strong defense. A dissenting creditor can challenge a plan if they can show they do better in liquidation. This forces the debtor to produce a credible valuation. You can't just lowball creditors.
And the financial collateral holders.
Yes. For secured lenders with Luxembourg law financial collateral, their security being exempt from the stay means they always have a seat at the head of the table. Their position is uniquely powerful. Their agreement is often indispensable.
So the negotiation over the reorganization plan itself is the main event.
It's the central battleground, yes. And valuation of the business as a going concern versus its liquidation value becomes absolutely paramount. Everything hinges on that. And that cross-class cram-down mechanism adds another layer of strategy. A debtor can now focus on building a coalition with just one or more creditor classes to hit those voting thresholds. This forces dissenting creditors to negotiate constructively rather than just digging in their heels and blocking everything. It's a much more dynamic process now.
And what about shareholders in all this?
Their role is explicitly secondary and significantly diminished in this new landscape. The law is very clear. The priority is preserving the business and satisfying creditors. Protecting existing equity value comes second if the business is truly in peril. #tag documentation, costs, and timelines.
So a successful reorganization requires meticulous preparation, sticking to the procedures. Documentation, costs, timelines, no room for sloppiness, it seems.
None at all. Filing for judicial reorganization isn't a simple form-filling exercise. It needs a comprehensive dossier. You need a detailed explanation of the facts showing the threat, a clear statement of objectives, recent annual accounts, a list of known creditors and what they're owed, and, if you're aiming for a collective agreement, a draft reorganization plan. The courts expect you to come prepared.
And the costs involved. Anything unexpected for companies?
Well, the direct costs are things like court filing fees and the pay for any court-appointed professionals, which the court determines or approves. As we mentioned, the operating costs of the government's evaluation unit, the SAU evaluation, are covered by the state, which is helpful.
And the company's own advisors, lawyers, financial experts.
Our sources don't specify or regulate pricing models for them. In practice, those fees are a matter of commercial negotiation, just like usual, following market conventions.
Okay. And the timelines. The law imposes quite a disciplined, relatively swift schedule, doesn't it? That must prevent things dragging on indefinitely.
It does. It's designed to be efficient. Key deadlines include: the court has to review the petition within 15 days and make its opening decision within 8 days after that review. The initial stay is max 4 months. The total duration, including any extensions, is capped at 12 months from the first judgment.
Tight.
Very. The debtor has 14 days to notify all known creditors about the opening judgment. If you're going for a collective agreement, the plan has to be filed at least 20 days before the creditor vote. And the voting hearing itself must happen at least 15 days after creditors are told the plan is available. Creditors wanting to dispute a claim, they need to do that at least 1 month before the voting hearing.
Wow, that's a structured and finite timeline. It imposes real discipline, forces everyone to be prepared and negotiate efficiently. That ultimately benefits creditors too, reducing uncertainty.
Exactly. It accelerates the resolution, one way or another.
Right. The real test of any legal reform is how it works in the real world. It's been over 18 months now since this law came into force. How's it actually being received? And what are the courts saying? #tag market reception and early case law. The law in action.
Well, the uptake was immediate. The first petitions were filed very shortly after November 1st, 2023. By late 2024, we know at least 24 judicial reorganization proceedings had been opened. That's a clear sign the market needed these tools and practitioners are using them.
And this early activity must have generated some vital initial case law. What are the key clarifications we've seen from the courts so far? Anything surprising?
I think the most notable thing is the pragmatic approach courts have taken to defining business in peril. They've established that a significant gap between liquidity and short-term liabilities is a strong indicator. But crucially, just having more liabilities than assets on paper without that immediate liquidity crisis doesn't automatically block reorganization if there's still a fundamental threat to continuity. They're looking at the real picture.
Makes sense. What else?
The Court of Appeal clarified the scope of transfer by court order. Yes, it can include foreign assets, but as we discussed, merely holding shares in subsidiaries isn't a transfer-referable activity. The focus is on active businesses. Courts have also held that a creditor's ability to block things can be undermined if their claim itself is credibly disputed. And that January 2025 ruling on Article 10 was pivotal. It really defined the judicial representative's role as a targeted fix for governance crises, stressing proportionality, not a complete takeover unless absolutely necessary. These rulings are building a very useful practical guide. #tag Luxembourg's unique selling points, USPs, in the European restructuring market.
So with this modernized framework now in place and being actively tested, how has Luxembourg really boosted its competitive position in the European restructuring market? What are its true unique selling points now?
I'd say the primary USP is that elegant blend of flexibility and robustness. It really offers the best of both worlds. For debtors, you get these flexible rescue tools from the confidential, amicable agreements right up to powerful judicial stays. And for secured lenders, you get that unwavering certainty that their security under the Luxembourg financial collateral law remains fully protected. That specific balance is quite unique and very attractive.
That all stands out.
Second, by faithfully transposing the EU directive, Luxembourg achieved full EU alignment and predictability. For international players, this harmonized framework is familiar, reliable, it reduces legal risks significantly. It's a known system, just upgraded.
Right.
And finally, the law creates a genuinely proactive and supportive environment for business preservation. Those state-led early warning systems, the government-appointed conciliateur d'entreprise, they signal a real policy shift towards rescue. And that immediate stay triggered just by filing a petition. That's another powerful debtor-friendly feature that encourages companies to act early, not wait until it's potentially too late.
Looking ahead then, what do you see driving the evolution of Luxembourg's restructuring landscape? Are there potential challenges or areas where maybe further tweaks might be needed down the line?
That's a key question. I think the most important near-term development will definitely be the continued growth of domestic case law. As courts tackle more complex situations, we'll see refinement. Judicial precedent will fine-tune how cross-class cram-downs work in practice, how the best interest of creditors test is applied, the precise balance of power between different stakeholders. I expect challenges around specific valuations and how those tests bite.
And on the wider European stage?
Well, harmonization is still ongoing. The European Commission's late 2022 proposal for a directive on substantive insolvency law shows there's continued push for deeper integration across the EU. That could potentially lead to further adjustments to the Luxembourg framework in the future to stay aligned. It's a landscape that will keep evolving.
So in conclusion, it really seems the Law of 7 August 2023 has successfully and decisively modernized Luxembourg's whole approach to restructuring and insolvency. It's equipped the Grand Duchy to handle today's economic challenges, fix that historical oddity we discussed, and really cemented its position as a top-tier European hub for setting up, financing, and, when needed, reorganizing complex structures. An exciting development.
A very significant step forward, absolutely. Hashtag tag outro.
To conclude, let's just quickly revisit the 3 most critical takeaways from our deep dive today. First, Luxembourg has fundamentally shifted its approach to corporate distress. It's embraced a new philosophy of rescue. The Law of 7, August 2023, provides a modern toolkit designed specifically to preserve viable businesses through flexible and powerful reorganization procedures. Second, for the financial community, the key message is stability. Those celebrated creditor-friendly protections of the Luxembourg financial collateral law, they remain fully intact, fully enforceable, even within a reorganization. This cements the Grand Duchy's status as a top-tier financing jurisdiction. No question there. And third, this law is well and truly alive. It's not just words on paper. Emerging case law is actively shaping its practical application, providing essential clarity on how these new tools work in the real world. This makes the framework more predictable, more effective for everyone involved. Practitioners now have concrete guidance, not just legal theory to wrestle with. It really shows how Luxembourg continues to adapt and lead in modern financial law. This podcast uses AI-generated content. All information is for general purposes only and does not constitute financial, investment, legal, or regulatory advice. Listeners should verify information independently and consult qualified professionals for personalized guidance. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.